Welcome to the Deep Dive. Today we're exploring a really significant piece of legislation. It's not just for lawyers, but for anyone interested in how laws shape basic human rights and healthcare. We're diving into South Africa's choice on Termination of Pregnancy Act 92 of 1996. Our goal here is to, unravel this essential act. We'll look at its purpose, break down the key rules, trace its interesting legal journey, understand what it means practically, and sort of grasp its real-world impact. Get ready for some crucial insights, maybe even some surprises about how law touches personal autonomy.
Absolutely. And this isn't just some dry legal text we're talking about. This act, it represents a huge shift in South African law, a definite move away from a very restrictive past towards a present that really affirms rights. It's a powerful example of rights-based lawmaking.
Okay, so let's start right there. Why? Why did South Africa need an act like this, specifically in 1996? It was signed into law in November 96, started Feb 97, a pivotal moment, right? Post-apartheid South Africa.
Exactly. To really get it, you have to look back. This act specifically explicitly repealed the old Abortion and Sterilisation Act of 1975. Now, that old act was incredibly restrictive, often completely inaccessible for many women. So that repeal itself tells you a lot about the new direction. A conscious move away from state control towards, affirming rights, especially bodily autonomy.
Right, replacing the old framework entirely.
Precisely. And if you want the real heart of this act, you just need to read the preamble. Seriously, it's not just legal fluff. It's a powerful declaration of values deeply rooted in the new Constitution. It explicitly recognizes things like human dignity, equality, security of the person, non-racialism, non-sexism, the foundational values.
So it ties reproductive rights directly to those core constitutional principles.
Yes, exactly, which is quite smart, legally, embedding it right from the start. It also recognizes the right to make decisions about reproduction, control over one's body, and crucially, the right to access safe, effective, affordable, acceptable methods of fertility regulation. It also lays out the state's duty, its responsibility, to provide reproductive health services and safe conditions for people to exercise this choice. And it makes a very clear point. Termination of pregnancy is not presented as a form of contraception or population control. That preamble really sets the ethical stage.
That's a very strong value statement, especially thinking about the history. Now, you mentioned it wasn't static. It started in 97, but changes were made up to February 2008. What happened there?
Right. It had quite a legal journey. There was a significant constitutional challenge. Amendment Act from 2004, Act 38, was actually declared inconsistent with the Constitution. This happened in a really important case, Doctors for Life International v. Speaker of the National Assembly.
Ah, the Doctors for Life case. I remember that.
Yes. It really showcased this dynamic interplay between laws passed by Parliament, the courts checking them against the Constitution, and fundamental rights. What happened was the Constitutional Court found fault with the process Parliament followed, but it didn't strike the law down immediately. Instead, the court suspended the order of invalidity for 18 months.
Gave Parliament a chance to fix it.
Exactly. To reenact the law in a way that was constitutionally sound. And that led directly to the 2008 Amendment Act, Act 1 of 2008. It's a textbook example of constitutional democracy in action, testing and refining laws.
And did those amendments bring practical changes?
Yes. A key practical one was about who could perform terminations. The phrase registered midwife was, in many places, replaced with registered midwife or registered nurse, as long as they had the prescribed training, of course. This broadened the pool of healthcare providers significantly.
Expanding access, essentially.
Precisely. A very practical outcome.
Okay, so with that foundation set, let's get into the nitty-gritty. How does this act actually work for someone needing care? Section 2 seems key. Circumstances in which and conditions under which pregnancy may be terminated. It looks like a tiered approach based on how far along the pregnancy is.
Yeah, that's right. So for the first 12 weeks, it seems quite straightforward.
It is. During the first 12 weeks of gestation, a termination can happen simply upon the request of the woman. Full stop.
Wow, okay. Very direct emphasis on choice.
Absolutely. Then things change a bit from the 13th week up to and including the 20th week. Here it requires the opinion of a medical practitioner. They need to consult with the woman, of course, and then conclude that certain conditions are met.
What kind of conditions?
Several possibilities, like if the continued pregnancy poses a risk to the woman's physical or mental health, or if there's a substantial risk of a severe fetal abnormality, or if the pregnancy resulted from rape or incest, or even if continuing, it would significantly affect the woman's social or economic situation.
So more factors come into play after 12 weeks. Correct. And then after the 20th week, the threshold is higher again. Now you need the opinion of 2 medical practitioners, or alternatively, 1 medical practitioner and a registered midwife or registered nurse with the proper training. And their opinion must be that continuing the pregnancy would actually endanger the woman's life or result in a severe malformation of the fetus or pose a risk of injury to the fetus.
A clear, stepped approach, balancing autonomy with increasing medical considerations as the pregnancy progresses.
Exactly. It's a carefully structured framework.
And you mentioned earlier who can perform these. Section 2.2. Right?
Yes, Section 2.2 clarifies that. Generally, it's a medical practitioner, except for those first 12-week terminations, the ones based purely on request. Those can also be done by a registered midwife or registered nurse who's completed the required training.
Which connects back to that amendment you mentioned.
Precisely. Broadening access, especially important in areas maybe with fewer doctors readily available.
The Act also seems very careful with definitions like minor, rape, incest, often linking them to other specific laws for clarity.
Yes, precision is key in legislation like this.
Okay, this brings up a practical point.
Yeah.
Where can these terminations actually take place? Let's talk about Section 3.
Right. Section 3 lays out the requirements for the place of termination. It's quite specific. It has to be a facility with appropriate medical and nursing staff, an operating theater, surgical equipment, resuscitation capabilities, infection control, safe waste disposal, proper medical infrastructure.
Sounds like specific standards need to be met.
They do. And generally, these facilities need formal approval from the provincial member of the Executive Council, usually the health minister, published in the official gazette.
So a formal approval process.
Usually. But there's a really important exception in Section 3A. It's designed to make things easier, practically speaking.
Yeah.
Any health facility that already runs a 24-hour maternity service and meets all those other facility requirements we just listed, that facility can perform terminations up to 12 weeks without needing that explicit formal approval published in the Gazette.
Ah, okay. So existing maternity units that are properly equipped can provide early terminations more easily.
Exactly. They just need to notify the member of the Executive Council that they meet the criteria. It's a pragmatic way to increase the number of access points, especially in perhaps more remote or underserved communities.
That makes a lot of sense. Now, what about support around the decision? Section 4 talks about counseling. It says the state should promote non-mandatory and non-directive counseling before and after. That non-mandatory part seems really important, doesn't it?
Hugely important. It ensures counseling is offered as a support, a resource, if the woman wants it. But it cannot be a requirement, a barrier, or a hurdle she has to jump over to access the service. It truly respects her choice. Non-directive also means the counselor isn't there to push her one way or the other.
Right, support without coercion. Okay, now for what seems like a cornerstone. Section 5, consent. This sounds like where the autonomy aspect really comes through.
Absolutely. This section is incredibly powerful. Section 5, 1, and 2 are crystal clear. They state that terminating a pregnancy requires only the informed consent of the pregnant woman herself, period.
Only her consent.
Only hers. It explicitly says no other consent is required, overriding any other law or common law rule that might suggest, say, spousal consent is needed. It's a profound affirmation of individual bodily autonomy.
That's incredibly clear. What about minors, though? People under 18?
The Act addresses that very carefully in Section 5.3. A medical practitioner or midwife must advise a minor to consult with her parents, guardian, family, or friends. It's advice, a suggestion for support. However, and this is the critical part, the termination cannot be denied if the minor chooses not to consult them.
So her choice is ultimately protected even if she's under 18?
Yes. It balances the potential benefit of family support with the ultimate protection of the minor's right to choose and her confidentiality, a very sensitive handling of a difficult situation.
And what about situations where a woman can't give consent herself, say due to severe mental disability or being unconscious?
Section 5, 4, and 5 cover these complex and thankfully rare scenarios. For terminations up to 20 weeks, consent can potentially come from a natural guardian, spouse, or legal guardian. If they can't be found, a curator personae, someone legally appointed to manage their affairs, can consent. But, and this is a key safeguard, 2 medical practitioners, or 1 practitioner and a trained midwife nurse, also have to agree that the termination is necessary. It's not just the guardian's decision.
Okay, a double-check mechanism.
Right. And for terminations after 20 weeks in these situations, the medical practitioners, or practitioner and midwife nurse team, can consent after consulting the guardian or spouse. But here's the really crucial part. The termination cannot be denied even if that guardian or spouse refuses consent.
Wow. So the medical assessment of a woman's health needs takes precedence.
Exactly. In these highly vulnerable situations, the Act prioritizes the woman's life and health above potential objections from guardians, ensuring medical necessity guides the decision.
It really seems like every angle of consent and autonomy has been considered. And Section 6 adds that the woman must be informed of her rights under the Act. Okay, so the procedure happens, consent is handled. What about records and privacy? Section 7 deals with notification and records. How does that work?
Section 7 sets out the procedures. The practitioner or midwife nurse who performs the termination has to record certain details in a specific format. The person in charge of the facility then gathers this information and sends it confidentially to the provincial head of department, usually within a month.
What kind of information, and is it kept private?
It's procedural and statistical information.
Yeah.
But here's the vital privacy safeguard. The Act explicitly forbids including the name and address of the woman in the information sent to the head of department.
So it's anonymized at that level.
Completely. Her identity remains confidential unless she herself chooses to share that information.
Yeah.
It's a crucial protection, balancing the need for public health data with the individual's right to privacy in a very sensitive matter.
That's a really important balance to strike. So we've covered the why, the who, the when, the where, the how. Now that's so what. What about enforcement? Accountability, making sure these rights are protected in practice.
That takes us to Section 10, Offenses and Penalties. This section gives the Act its teeth. It lays out serious consequences for violations. For example, performing a termination without the right qualifications, not being a doctor, or a properly trained midwife or nurse is a criminal offense.
Okay, so only qualified people can perform them.
Yes, and performing one in a facility that hasn't been approved or doesn't meet the standards is also an offense. But perhaps the most powerful part of Section 10 in terms of protecting access is that it criminalizes anyone who prevents a lawful termination or obstructs access to a termination facility.
So you can actually be penalized for blocking someone from getting this care.
Absolutely. It's a strong message that interference with this legal right will not be tolerated. It aims to safeguard access directly.
And the penalties.
They can be quite severe. For major offenses like performing illegally or preventing access, it could mean a fine or even imprisonment for up to 10 years. For things like failing to keep proper records, it's less severe, maybe up to 6 months.
So real consequences. And this applies everywhere in South Africa.
Yes, the Act explicitly states it applies to the whole national territory of the Republic. Uniform application.
It's comprehensive.
It is. And when you link it all back, the preamble, the careful structuring, the consent provisions, the privacy rules, the penalties, and even that Doctors for Life case showing how it interacts with the Constitution, you really see a complete picture. It demonstrates how legal frameworks evolve, get tested, and try to balance individual rights with societal views, all under a constitutional democracy.
This deep dive has really illuminated the choice on Termination of Pregnancy Act. We've seen its meticulous design defining circumstances, ensuring qualified care, safeguarding privacy, and crucially, criminalizing obstruction. It maps out a path for a deeply personal healthcare choice.
It really does. And it shows how one law can reflect the nation's core values, like dignity and equality, protect fundamental rights, and grapple with complex social issues head-on. It's a testament, I think, to how law continues to evolve and function in a democratic society, trying to uphold constitutional ideals in practice.
So thinking about this detailed framework the Act provides, what does it ultimately tell you, our listener, about the role law plays in trying to balance individual liberty with societal responsibility when it comes to these deeply personal life decisions? Something to ponder.